So a very nice evening to everyone. Welcome back to the fourth session, which happens to be a plenary session. And this is about artificial intelligence, intellectual property, and competition and economic perspective. Right before the break, we had the first keynote by Professor Jan Weissman, who broke the ice with intellectual property, Professor Kamperman Sanders, and Professor Julian Novak, who presented a bit of a background work. We take this a step further, and in this session, we talk about things on intellectual property and competition from an interdisciplinary perspective, wherein I have the absolute pleasure, and I'm very, very thrilled to welcome Professor Daniel L. Rubinfeld, who is a Robert L. Bridges Professor of Law and Professor of Economics at the University of California, Berkeley, and Professor of Law at the New York University. He has also served as Assistant Attorney General for Antitrust in the U.S. Department of Justice. He has many wonderful books to his name, and he has also been a fellow at the National Bureau of Economic Research, the Center for Advanced Studies in the Behavioral Sciences, and the John Simon Guggenheim Foundation. He also received an honorary doctorate from the University of Basel. This is but very little that I can say about Professor Rubinfeld. So a keynote by Professor Rubinfeld next, and I'll start sharing the slides. Welcome. You would have to unmute yourself. And I'm sharing the slides now.
Can you hear me now?
Yes, we can.
Okay. Thank you, Kapi. I appreciate the introduction. I assume I've got about 30 minutes, no more. Is that correct?
Yes, indeed.
So let me begin before I start the slides by, first of all, saying hello to, if he's around, to Michael Faurer, who I haven't seen personally in a while, but we go back at least 30 years, Michael. So it's nice to see you in person. And I also wanted to apologize in the way I would normally be there in person, but I've had to cut back my travel because of my wife's health. And I'm sorry about that. And I also wanted to pay particular note to Julian Novak, whose really interesting paper on AI and predation had an impact on the draft paper that Michal Gal and I have written. So thank you, Julian. This is a draft. Will be revising the paper for publication in the Antitrust Law Journal. So any feedback any has for us would be greatly appreciated. So the paper that we're giving has extensive citations to the literature.
I'm sorry, Professor Rubinfeld, we can't hear you very well.
That's the problem. So can I speak more loudly? Would that help?
Yeah, he needs to speak into the microphone. We would request if you can just speak directly into the microphone and you may be audible then.
Fortunately, I'm right near the microphone. Does this help at all?
Yes.
Okay, I will do my best. So the slides that we're going to present omit citations to literature just to keep it simple. The main point of our paper is to suggest that when looking at mergers that involve AI, we need to take a harder look and very likely to be tougher on mergers that otherwise might not be problematic. In order to do that, I need to sort of set the stage. The literature on algorithms generally focuses mostly on coordination and says relatively little about unilateral conduct. So I'm going to overview both of those and then explain why Michal and I think we need to take a harder look at mergers involving AI. So before I start the slides, can you hear me okay now?
Yes, it's a bit fuzzy, right? No, okay. Yes, please go ahead.
Okay, so You can start the slides now and turn to the next page. Let's see. Let's see, make sure that I can see these slides. Wait just a second. I want you to be, I'm having a little trouble. I want you to be on the slide that, the first slide you can, that just talks about what algorithms are. Algorithms are very widespread. The only thing that's different now is that algorithms that are powered by AI can be particularly beneficial, but also particularly problematic. So you can turn to the next slide if you can, after what are algorithms. You can actually, some of the slides are just to entertain you. So this just describes what AI is about. You can move to the next slide, and you can actually go to the next slide after that. Now, this slide on monitoring pricing points out something that worries both of us and did worry OECD, and that is algorithms have a way of collecting price data, transmitting them, and avoiding the possibility of harmful price wars, and therefore raise the likelihood that coordinated behavior could be anti-competitive and harmful, even though there is no exchange of information or no activity that would normally be traditionally considered to be anti-competitive under US or EU law. So we have to think very carefully about what happens when we look at mergers that allow monitoring pricing of competitors, and we would suggest increase the likelihood of coordination occurring, which would otherwise be legal under both EU and US law. You can turn to the next slide. So just one second. So I just summarized here some statistics about how widespread algorithms are. This is based on data that's some years old, but you can see from the slide that there's extensive use of algorithms to do pricing. A lot of these algorithms are pro-competitive and not harmful, but they do raise the possibility that the exchange of pricing information can be problematic. So let's turn to the next slide. So what strikes Michal and I is that there are certain principles that we ought to pay particular attention to. And the first is that if there's conduct that's prohibited, if we're conduct without AI, without algorithms, we ought to apply the same principle to algorithms. That seems like a reasonable basic principle, but when you think about the use of algorithms, I'm not so sure anymore whether that is the right principle that ought to go forward. But nevertheless, it seems to us that algorithms that should not change the basic economic principles that all of us use in analyzing competitive behavior. And particularly when innovation is involved, AI can be very pro-competitive. And we're just going to need to delve more deeply into the underlying economics that explains how AI relates to innovation. You turn to the next slide. So I'm going to start by talking about coordination, about which there is quite extensive literature. You can turn to the next slide. So I will go fairly quickly through the coordination issues. There has been extensive case law in the EU looking at collusive behavior, and I mentioned a couple of cases here, both in the US and in the EU. And you can turn to the next slide. So the next slide is just a visual description of typical concerns we might have with hub and spoke coordination. The only point here is that if we are going to have a relationship, say, between firms that have a relationship with a common supplier, when algorithms are available, particularly as powered by AI, the supplier can very effectively achieve a coordinated outcome using AI to make the coordination more likely than would occur without AI. So coordination can be, again, pro-competitive, but AI makes me, and I think others, worry about the classic case of hub and spoke coordination. You can turn to the next slide. So I just illustrated here some ways in which algorithms might be problematic, and I won't go through the details, but with each of the algorithms that we've laid out here, the algorithms can basically create a simple pricing mechanism, kind of a tit-for-tat arrangement, where the algorithm basically sets price, looks at what the competitor's price is. If the algorithm says the competitive price is not satisfactory for achieving a coordinated outcome, the algorithm will reduce its price substantially, which should create immediate response by the competitor to raise the competitor's price. And you can imagine, without any human coordination beyond the use of the algorithms, that this algorithm A that I've described, by basically using a tit-for-tat operation, can achieve a collusive outcome without any formal coordination, no information being exchanged by the two firms, simply each firm letting its algorithm be powered, letting it go, and you can achieve a coordinated outcome. And the algorithm B would achieve the same thing. So the suggestion we have is that when firms are getting together, particularly through mergers, as we'll see in a minute, when the mergers involve the use of algorithms, those mergers could achieve outcomes we would suggest that would be coordinated, whereas the merger that did not involve the use of algorithms would probably go through without a problem. So those of us who thought a lot about variations on the tit-for-tat model need to think even harder about the implications of tit-for-tat and variations when mergers involve algorithms. So you can turn to the next slide. So the question, just a second. So can algorithms learn to coordinate? Well, OECD said yes, and we agree with that. I've just taken a quote directly from an earlier OECD meeting concerning algorithms. And OECD says, by providing companies with powerful mechanisms to monitor prices, implement common policies and market signals and so on, that can enable firms to achieve the same outcomes that would be achieved through hardcore cartels. So bottom line is, we've got to worry about the possibility that algorithms will allow what otherwise would be legal, tacitly collusive behavior to achieve an outcome that we would all think would be problematic. So this leads us to think about, you can turn to the next slide, to go back and think about the traditional analysis we all do in antitrust to look at conditions for coordination. And we need to ask ourselves, how are these conditions changed when we have algorithms? And we'll suggest, we do suggest in the paper, that algorithms increase the possibility for agreements, make it easier on some conditions to detect cheating when firms are attempting to collude through an agreement, and in fact can find other means for imposing sanctions when it might otherwise be difficult to sanction those that break from cartel behavior. So the conditions for coordination essentially get raised to a heightened degree of attention when AI-driven algorithms are involved. You can turn to the next slide. So here we just outline conditions for an agreement. Again, we suggest that with algorithms, the algorithms can do calculations faster than humans, and they can allow firms to make decisions to support coordinated outcomes that would be in the interest of each of the firms. And the firms may, in fact, be aware that each of its competitors have algorithms, how the algorithms work, and they can use the algorithms to signal behavior that would be more difficult to signal if there were no algorithms involved. You can turn to the next slide. So it is possible, of course, that with algorithms we can detect anti-competitive behavior more effectively, and by doing that, there is the possibility that we can use algorithms to reduce the incentives for firms to deviate in terms of harmful behavior, but also to deviate in terms of maintaining a cartel. So the story for algorithms is both positive and negative. We can use algorithms to achieve anti-competitive outcomes, but we also can use algorithms to sanction behavior that would otherwise be illegal. And we suggest at the bottom, and I'll talk about briefly in a minute, that the implication of algorithmic behavior depends very heavily on whether the mergers we're looking at involve homogeneous products or whether the products are heterogeneous. The problem gets particularly complex when products are heterogeneous. I can get back to that a bit later. Normally, with heterogeneous products, it's very difficult to achieve collusive outcome, and we don't typically worry about this so much. But with algorithms, the algorithms allow firms to be more sophisticated in the behavior, and that can be both pro-competitive, but also can be anti-competitive. So the bottom line from Koolen myself is we need to look harder at behavior that might otherwise be seen as pro-competitive, and to see what happens, how that behavior is affected by algorithms. It's harder to do that outside the context of mergers because of the existing case law, although we have new variations, but it may be easier to deal with the problem with algorithms whenever mergers are involved. So you can turn to the next slide. So we were particularly interested in experiments that others have done, and I just cite one paper here that we found particularly interesting that showed that through simulations that with algorithms, it's a lot easier to achieve collusive behavior. Now, a lot of the algorithmic papers about simulations do not tell us about how many iterations are involved or how long it would take. So we don't know for sure exactly what implications to draw from a practical point of view, but we think the time has come to be quite worried about those implications. So let's turn to the next slide. What makes AI particularly special? Since we've had algorithms for a long time, we would suggest that algorithms are getting pretty sophisticated. Among other things, they can create other algorithms involving AI. Available data basically has improved the complexity and sophistication of algorithms. And again, we think the point of focus needs to be on mergers, and to ask ourselves, when mergers involve sharing of algorithms, or more importantly, sharing the data that algorithms might utilize, we have to take a look at the possibility that these mergers might be anti-competitive. You can turn to the next slide. So, should we worry? Yes, we should. What's most worrying is that if we have algorithms, we don't know exactly how the algorithms necessarily behave. They can collude by trial and error. They don't need to know or have prior knowledge of the environment which they're operating or communicating, and they don't have to be instructed to collude. So if we're going back and looking at collusive behavior and trying to look at searching documents or other information, there may not be the kind of track record that those of us who've been enforcers have looked for when we're trying to go after collusive behavior. There may not be that kind of footprint that would make it easier to track down anti-competitive behavior. Now, I'm saying a lot of negative things about algorithms, but of course there are lots of pro-competitive advantages as well. So I believe we should worry, And we should worry not only about coordination here, but we also need to worry about non-coordinated behavior. So I'm going to turn to the next slide. Just summarize for those of you who are more interested in the case law. The Tompkins case interested us because there were variations on Tompkins case both in the UK and the US. I cited here a quote from the CMA decision over in the UK. Excuse me for just a minute. And the CMA explains how algorithmic tools can help, even though automated, to help sellers compete better for the benefit of consumers. However, the parties can also use algorithmic-based software to implement legal agreements to deny consumers those same benefits. Next slide. I think I will skip this. This is a case many of you would know about coordination involving online booking systems in Romania. Excuse me, in Lithuania. You can turn to the next slide. I was particularly, given that I mostly do U.S. Law and economics, I was particularly interested in U.S. cases. You can turn to the next slide. I think I want to look at. Hang on a second. Yeah, so I wanted to point out that when we're looking at algorithms, we normally would ask, what are the goals of the algorithms? Are they intended to achieve certain goals? And if the algorithms can be shown to achieve coordinated outcomes, that would be problematic. But it may not be very easy to detect that behavior. So it may be that we need to look at communications, but it may be difficult to go after communications that would otherwise be problematic. If the algorithms are simply reacting to what competitors are doing, there may not be an agreement of the kind the law would normally focus on, even though the algorithms may achieve a coordinated outcome. You could turn to the next slide. This is a slide that I presented because I suggest some of you look at my colleague's paper on algorithms as legal agreements. And Michal suggests in her paper published a couple of years ago in the Berkeley Technology Law Journal, some suggestions about how we look at algorithm behaviors and to see whether the algorithms are really facilitating an equilibrium which is anti-competitive or not. I will skip the details. I suggest that you take a hard look at that agreement. So most of what I've talked about so far is well known. We know less about unilateral behavior. So let's turn to the next slide. I want to talk briefly about algorithms as facilitators of abuse. I will try to be quick about that. Turn to the next slide. There are various sorts of unilateral conduct where algorithms can make a difference, and I've listed them here. The first one that you can turn to the next slide is discrimination. If we haven't covered that, yes. So algorithms can increase the probability of discrimination. Price discrimination is not necessarily illegal, but it can, in some cases, be anti-competitive. In our paper, we point out how algorithms can make discrimination problematic and can do things that would otherwise not be achieved without algorithms. Next slide. I'll move quickly because I want to get to mergers before I run out of time. In the paper that I think Julian wrote, his co-author suggests problems with algorithmic predation. We agree that those are problematic, and we suggested here some of the ways where algorithms change our usual assumptions about whether predation is problematic or not. For example, below cost predation is normally seen as not a problem because it's very difficult for such a practice to be effective. Algorithms really change that story. And I think UberText is an example. I think low prices set in this case can be very effective in achieving anti-competitive outcomes. Next slide. So we think about remedies. Algorithms change the story. I mean, we can imagine remedies where we say you can proceed with the merger, but you have to change parts of the code that might be problematic. We could think of, we wouldn't normally be thinking of this if we didn't have algorithms. We wouldn't go in and say as a remedy, you have to actually change your IP. That raises all kinds of questions for those of you who do IP law, but it's an intriguing possibility for those of us who do competition law. You can turn to the next slide. Another remedy might be to share the algorithmic advantages. We're going to say, yes, you can proceed with the merger, but you've got to make some of the IP that associated with the algorithms available to others. If the information is unlawfully obtained and gives you a comparative advantage, we think such mandatory sharing should be given serious consideration. Next slide. So we've listed here, I won't go through it, we've listed some of the questions I think we need to ask about algorithms, especially when mergers are involved. What are the algorithms really doing? What's the goal of the algorithm? What are the users going to do with it? Are there benefits? Are there costs, and so on and so forth? Again, I will not go through all the details. Our purpose here is to try to just get you guys asking really good, hard questions. So change to the next slide. I will skip through this. This is a focus on conduct, which we think is important. We do think that when we're looking at mergers involving algorithms, we can delve deeply into what the purpose of the algorithms are, how they're designed, and what the goals are, and that might allow us to achieve remedies that we wouldn't be able to achieve otherwise. Now, with respect to merger policy, I think I've got about 5-10 more minutes. I wanted to suggest some of the things we can do when we're looking at mergers. And you can move on to the next slide. You can slide or two, please. So when you're thinking about algorithms and mergers, first thing to realize is we may not need to worry about mergers, because if the algorithms allow you to achieve a coordinated outcome, the parties aren't going to want to merge anymore anyway. Some of the mergers that I've seen that might be worried about with possibility of coordinated outcome occurring post-merger would be mergers that the parties might not bother with, because they've found that the use of their algorithms could achieve coordination in any case. That's just a worry I have. There's not much we can say about it. But it does suggest to us that the agencies, both DG Comp and the US agencies, should consider the reporting thresholds. There could be thresholds which would not have a merger reported. Nevertheless, if the merger involves algorithms, coordination could be a real problem. So we would probably require more mergers to be reported than would be required otherwise if algorithms are involved. We would also give greater weight to cases where there are asymmetries. Normally, we think of asymmetries not being problematic because asymmetries create a system where the parties would normally compete with each other. Algorithms allow asymmetries to be overcome, particularly if they're powered by AI, and that suggests we ought to broaden the kinds of mergers we worry about. We even think conglomerate mergers, where there may be vertical issues but no horizontal issues, now become problematic when AI is involved. We also worry that traditional structural remedies may be less effective. You can turn to the next slide. So what do we do? How do we handle algorithms? Well, we go back to some of the basics for the way those of us doing competition policy analyze mergers. And even though I'm a big fan of the SNP test for deciding, for evaluating mergers and thinking about whether horizontal mergers are problematic or not, and even defining markets, we think some of those tests really are not going to work terribly well if the markets are not homogeneous. I won't go into that now because I could bore you and talk for hours about it, but we do think that some of the very classic tests that the competition agencies use need to be revised. And we've listed here some of the examples of things we need to worry about. We even worry about where third parties can manipulate the algorithms. Again, it's not all bad because algorithms can be used to counter abusive behavior, and they can learn in ways that can be pro-competitive. So we think we need to worry harder about remedies that take advantage of the benefits that algorithms provide. And that suggests the possibility of sharing some of the IP that are associated with the algorithms. So the next slide suggests that some of the key merger issues involve what are the comparative advantages that arise when AI is involved? Are there important synergies involving data? Are there important analytic capabilities? But is there the possibility of foreclosure of access to essential data, to essential algorithms, and the possibility of eliminating competitors? So we think that greater attention needs to be given to the fact that mergers can increase the possibility that unilateral conduct will be problematic. You can turn to the next slide. Kalpi, I assume I have five more minutes or so. Is that correct?
Yes, please take your time.
Okay. I will. You can cut me off if I go too long. So in the paper, Michal and I reviewed a whole bunch of different mergers, some in the US and some over in Europe. And we asked ourselves, how would we look at mergers differently when AI is involved? And I'll just pick one as an example that happens to interest me because I've followed the Live Nation Ticketmaster merger in the US. I do have a bit of a bias because I've done a lot of work with Eventum over in Europe, which was not very happy with the Live Nation Ticketmaster merger, nor was I. The merger went through because it was seen as primarily vertical, and the Department of Justice, as Christine Varney explained, saw benefits created by the merger, allowing Live Nation, which does venues, to more efficiently manage those venues through a single primary ticketing agency, Ticketmaster. It did provide for a remedy which required some sharing of IP, which was largely ineffective in my view. The IP was never really utilized to create a competitor for Ticketmaster in the US, and Ticketmaster still basically monopolizes most ticketing markets. What the merger missed was the fact that the parties were sharing data that allowed the combined ability through AI, through algorithms, to have more effectively designed pricing for the various venues that people are exhibiting. And that was never really, in our view, fully accounted for. If I were looking back with hindsight at that merger, I would likely have blocked it, and I would have focused more carefully on the data that was being shared, because data sharing, data is basically the key input for algorithms. And if you're sharing data that would otherwise be available, the shared data can allow algorithms powered by AI to be much more effective. Now, in some cases, that'll be beneficial because the algorithms are doing things that are pro-competitive. But in other cases, like Live Nation Ticketmaster, we think that the algorithms have actually allowed pricing and price discrimination to be more effective. And I would suggest you'd see the evidence of that if you go to any Live Nation motivated performance in the US. And I think we would see similar evidence, equivalent evidence over in Europe. So I'll stay with that, but I urge some of you to go back and take a look at some of the other cases we've outlined, because in all the cases we've outlined, there is the possibility of AI-driven algorithms to make a difference. And the difference, again, is not just caused by the sharing of the algorithms per se, but by the sharing of the data that makes the algorithms more powerful. So you could turn to the next slide. So what now? What now? Well, I think we need to acknowledge these risks more carefully. I've been encouraging the US without great success yet to really explicitly acknowledge the problems with algorithms in the horizontal merger guidelines under revision, to say specifically, we, the U.S., are going to look harder at mergers that involve AI, both at the benefits and at the potential risks. We also think we need to have an explicit toolbox really suggests conditions under which we can detect algorithms being problematic. This means not just involving the usual economic experts, but involving data scientists who understand much better than I do about what happens when you have better access to data for algorithms, and to really study in more detail how algorithms can be used both for detection and analysis. And again, the story is not all negative. I'm preaching about some of the problems, but there are a lot of pro-competitive benefits that are created by the algorithms as well. So what now means just a deeper dive into what happens anytime we have mergers that involve algorithms. So you can turn to the next slide. So we just outlined here some possible suggestions and solutions for what happens when we look at mergers. We need to look beyond the traditional conditions that are needed for thinking that coordination might be a problem. We need to be aware of the fact that there may be behavior that wouldn't require mergers in the first place. We may want to go back and look at deals that we've otherwise passed through that now we realize are problematic. We need to realize that structural remedies, which most of us favor over behavioral remedies, may be less effective when algorithms are involved. Those of us who like structural remedies need to look and take a deeper dive at whether those structural remedies are really going to be effective. Now, we need to account for the fact that algorithms can be, again, pro-competitive. They can be disruptive. We go through in the paper some examples of algorithms can create noise. Noise on the supply side can actually can be pro-competitive. The same thing on the demand side. It can make it harder for firms to coordinate if the algorithms are designed correctly. So again, the story is kind of mixed. You can turn to the next slide. We also think this is a pretty hard-nosed suggestion. We think that there are cases where, when we're looking at mergers, that we may want to take a really hard look at the remedy that requires the mandatory sharing of the algorithms. The merger goes through, but only with the requirement that the key AI-driven part of the algorithms be shared as part of the remedy, particularly if we see that there's anti-competitive behavior that has been engaged in the past or is likely to be engaged in once the merger goes through, and any unlawfully acquired comparative advantage should be removed, either removed or at least shared equally by all those who compete. So the bottom line for us is we have a lot to study. We particularly have a lot to study with respect to mergers that involve unilateral conduct that would otherwise not be seen as problematic. That story now changes. So I'm going to stop here because I want to make sure we have time for questions and discussion. I do want to point out, as I do, I think, on the next slide, that if you can turn now, turn past that slide, that this, the next one, please, Kalpi, that this was brought to you either by me or ChatGPT. You can decide which. Thank you very much, and I look forward to your comments and questions.
So I'll stop the screen share. Thank you very much, Professor Rubinfeld, for that lovely presentation and keynote. To the audience, if you have any questions, please.
By the way, I'll take answers. If you have answers, you can skip the questions. Just go directly to the answers.
Thank you very much for that wonderful paper. Just one question for you. Have you looked at consumers perhaps using AI tools in order to disrupt distribution chains? Because that could also be a possibility, wouldn't it?
It absolutely would. And we mentioned that briefly in our paper, but probably not as much as we should. But yeah, let me just give you, so I like your comment. Do you have any specific thoughts about how we might power consumers through AI? Because I do think that's an excellent suggestion.
That's very clever, putting the question back to me.
I'm always looking to learn if I can, but I do agree that's an excellent point. But if you have specific thoughts, I'd love to hear them.
I can see that with certain AI tools, consumers, just like we now have sort of united consumers trying to influence pricing and enhance their bargaining position, for example, in obtaining fuel or something like that, by using AI tools could also become quite a powerful, much more powerful player in the market than individual consumers nowadays are. But somehow they would be united, but they would be united by using an AI tool. Just like on the flip side, we have also seen cases where, for example, car manufacturers, by using the same AI tools in order to control their stocks, were in actual fact colluding, not found to be colluding really because there was no agreement between them, but they simply agreed to use the same AI software tool. So it can also work the other way around. Consumers could also benefit from the use of AI platforms in order to increase their bargaining position.
Yeah, I think that's absolutely right. I was thinking back when you raised your question, whenever I've gone to buy a car in the U.S., the first thing I did was to, because I've actually done some work in the industry, was to try to analyze the pricing tool that the car seller was using, and to some extent, once I could do that, I could figure out the best strategy. And typically, when I would buy a car, knowing something about the pricing mechanism, I would go in and basically make a take it or leave it offer to the seller. And I found with that information that more often than not, this is like every 5 or 10 years when I bought a car, the seller would accept my offer. I would go in and say, look, I understand your algorithm. I'm going to take advantage of it. If I took that a step further and I operated with more sophisticated algorithm, I could, and I wasn't just buying cars where I could invest the time and effort. I could imagine using that tool more widely when I was shopping. It would be an interesting world, actually, and we may be there very soon, where consumers show up with their algorithms, the sellers have their algorithms, deals are struck fairly quickly, and if the algorithms of consumers are effective, that can be pro-competitive. If I were predicting the future way beyond maybe about my lifetime, I think we're going to see algorithmic consumers operating all the time.
Novak. Dan, thank you for a really excellent and interesting presentation. I was just struck by the proposals at the end. I was thinking about this. My thoughts were going into a similar direction, but as you said them, then I somehow thought like, oh wait, maybe that's not going to work out, because I was thinking about all the kind of personal data that might be exactly in those data sets. And I think if we think about the Google Fitbit one, that was also one of the main concerns. So I suppose if you wanted to share those data in there, you would again run into privacy concerns. And so that's one side. And then now, as you were talking, I was just thinking, maybe it's also that the consumers need to have access to that data to train their own algorithms on that data. But that's just like a thought I just had. Thank you.
Yeah, that's a very interesting comment. We had not thought about that very much, and we don't talk about that in our paper. But that would be the next step. I mean, I think we're actually our paper is mostly a review with a lot of suggestions and questions, and very few clear-cut answers. And that's one area where I just think we have a lot to learn. And so Michal and I have suggested a lot of possible remedies, particularly which we think are important in unilateral cases. But we have a lot to think through about the implications of those remedies. So if I were talking to some of our colleagues who are in the audience listening to this, if you're looking for an area for future research, I would suggest that's a great area for analysis. We don't know very much, at least I don't know very much about how some of these remedies, these merger remedies, would affect consumer behavior, and what happens when we start to power up consumers more, not only with algorithms, but with algorithms powered by AI. I think it's a great topic, and we say very little, if anything, about that in our paper.
I just have a quick question. I'll try to speak loudly. I think you recommended that potentially we could share, or as a remedy, require the sharing of the data amongst the competitors if it was unlawfully acquired. And I presume that we're drawing an inference to the criminal law fruit of the poisonous tree. Is that correct? And if yes, what might be the legal basis of the sharing of that? Because in criminal law, it becomes inadmissible, but here you're saying, let's extend that and share it amongst the competitors. But if it was unlawful in the first place, what might be that legal basis to allow that sharing to take place?
That's a great question. So yes, the answer to the first part of the question is yes, we're motivated partly from criminal law. With respect to the second part of your question, I really don't have a good answer because, first of all, I don't teach criminal law. I teach antitrust, and so I'm not sure how far I want to push that analogy. It just sort of struck us when we were thinking about possible remedies. So I don't know how far that can go, and I do realize that that would be a remedy that would be a very aggressive remedy in the way we described it, if it's sharing of IP. But it's not sharing IP is not a totally unusual remedy. When I was looking at the Nielsen acquisition of Arbitron, where I was working for Nielsen, by the way, the remedy that was proposed was the sharing of IP by the parties, and of course the party was the party's IP, so there was no criminal law issue involved, and the parties went along ultimately with the agreement that certain IP would be shared. So I do think sharing IP is still a possible remedy, but it's a pretty aggressive remedy, and it has only been utilized very selectively, at least in the US. So I don't want to go much further than that, than the criminal law analogy. I don't usually dip into criminal law when I'm thinking about what to do about antitrust, except when I'm thinking perhaps about cartel behavior, which is not what this paper is about.
Thank you.
Yeah. You have
Thank you. Thank you very much for the interesting presentation. I was wondering whether you could share some thoughts around where to draw the line between lawful unilateral use of algorithms that sort of learn a collusive behavior by themselves versus unlawful cartel-like use of algorithms, like in the poster case, which is a very nice example where companies used the algorithms as a kind of instrument to enforce a cartel that they had established. But where are the boundaries? For example, if algorithms are designed consciously to find a collusive outcome or to signal to their counterparts to price information and then find the collusive outcome, is that more like cartel, or is that still in the unilateral box and would be lawful?
That's a great question, and I don't have I'll tell you my views, but they're just my personal views. I don't think we have a clear answer to that question. My personal view is, and I apply this when I do my own analysis, both for the agencies and for private parties, but particularly for the agencies. I'm very interested in looking at the kind of communications that were part of the decision-making process. So I actually, unlike some of my economist friends, I actually want to go back and look at the discussions, the communications that occurred prior to particular arrangement being achieved. I understand, of course, that once everyone knows that that's what I'm going to be doing, life may change. But nevertheless, I think that's the way to go. And just as an example, when I was back in the Department of Justice, acting as a chief economist, looking at the Microsoft analysis, what led to the case we brought, I was very interested in what Microsoft had to say internally about their pricing and other behavior. And of course, everyone knows now that the discovery we did about email exchanges told us a lot about Microsoft's behavior. And so, in fact, back in those days, you couldn't communicate within Microsoft unless you communicated by email. So I kind of learned from that case. It's always led me to think we could go back and see what the parties were doing when they were actually thinking about a merger. I understand, of course, that once that becomes pro forma, that'll change the nature of the internal communications. But nevertheless, that's the way I would go. But I should say that my view is probably somewhat unusual. Some of my colleagues would say that's not what economists do. But that's the way that's the way I operate. I've learned a lot from seeing communications. And I think once you even tell firms you're going to be looked at the communications, it's very hard to get around that. If you're two firms or individual firms deciding on what's the legitimate pricing behavior, you're going to have to communicate internally. So that's the way I would go. But the law is not quite there. There's still real questions about how far we can operate with that procedure. But I think we've got to go there, and we'll learn. There will be people in the future designing algorithms, and other people thinking about how to hide what the algorithms are actually doing.
Thank you. Oh, one more question, please. You can say. No, I don't have.
Thanks so much for the presentation. I've got sort of two, or one question, one general sort of observation, and I'm not quite sure if I completely agree with the sort of focus on the sort of algorithms, sort of on the one hand. I completely see the threat of those being used, but for example, in the Yandex leak, there was sort of a while ago, the Yandex search algorithm was leaked. That's supposed to be the heart of search engine, and as it turned out, some of the code was very, very simple. It was like, well, if there's a Wikipedia article, then put it first, and those sorts of things. So at least in search, a lot of the competitive advantage comes from access to user search queries, as well as having the search index of websites, which is very difficult to generate, which would sort of, in that context anyway, make me think that maybe we have a data problem, less an algorithm problem. But coming to my question, my background is in computer science, and one of my collaborators in Oxford is to some leading researchers in studying algorithmic pricing. And now I asked him, like, because he published a paper recently in Nature Machine Intelligence, and asked him, well, you know, as researchers, what can we do to study these things, to detect these things from the outside? And he essentially said, well, you know, if these algorithms are sophisticated enough, then that's really, really difficult, if not impossible, to study from the outside. And so to the end of your presentation, you said that one of the remedies you envisage is hire data scientists and have them detect and study these things. And again, from the outside, that seems to be difficult, according to my friend. So I'm quite curious how the law and technical techniques could be combined, say, in terms of soliciting evidence from companies as to their algorithms. Maybe there are conflicts with trade secrets, I don't know. But do you have some thoughts on that, how, say, data science and laws could be combined?
Well, it's a great great comment. I would just say that I think we've got to figure out how to do that, how to make use of data scientists, because as algorithms get more and more sophisticated, the economists and certainly the lawyers are really not going to be sufficiently trained or prepared to really analyze what's going on with some of these algorithms. So I would say, for example, I were talking to my friends at the FTC or DOJ. I would say the next time you're hiring, let's say hiring an economist, maybe you ought to broaden that and find someone either who is a real data scientist or at least an economist who's got training in that area. But I will tell you, I don't know all the hiring at the agencies now, so maybe they're already there, but I would be surprised. But let me give you an example of why I'm somewhat optimistic. When we, again, going back when you asked, when we were pursuing Microsoft, which I was deeply involved with, we had to, the case involved in part how Microsoft designed its operating system. So we hired essentially a data scientist to testify for us. And he did, he was very, very successful. But I remember meeting with him in the room, and it was a very large room where he explained all the algorithms that were involved in Microsoft's source code for Windows. It was a very large table with all kinds of what I call subroutines. And even though I was a programmer, this was way above my level. But I said to him, I said, you know, you're going to need to testify. Can you explain to me how this works in 25 words or less? And I was joking. I thought that was just funny. He proceeded to give me an answer in 25 words or less. Of course, this led eventually to testifying for quite a long period of time. But I'm kind of an optimist. I think maybe because I'm not a data scientist, I think that the right data scientists working with those of us who do competition policy really can make a lot of progress. But I don't know that. I'm just I'm an outsider here. But Michal and I are both, actually her husband is a data scientist, but we're both optimistic about this. But we can't promise you anything because we're talking about the future. We're just imagining that this would be a place where there would be real progress. So good question, good thought. We'll see. And I hope some of the younger folks in the audience will help us move in this direction.
Professor Rubinfeld, thank you very much. I'm certain we still have many more questions. I do have a share, but as a chair, I need to move on to the next presentation now. We have a very interesting presentation coming up by Dr. Intan Hamdan Liveramento, who's a senior economist at the World Intellectual Property Organization. She's one of the 4 authors of the World Intellectual Property Report, one of WIPO's key publications. And I believe that you're going to talk about that publication, which is going to be the basis of the presentation today. So the floor is yours and the presentation is there.
Yes, exactly. Thank you. Is it on presentation mode already? Right? Perfect. Thank you. This one here? Okay, great. Let me just set my timer so that I don't prevent this from going to dinner and cause unnecessary hunger issues. All right. First of all, let me just thank Kalpana and her team for organizing this conference, this interdisciplinary conference, but also for inviting us, WIPO, to participate in the discussions. I have to say that I do feel a little bit like a fish out of water because a lot of the discussions here are very much legal based. And a lot of the work that I do are pretty much based on data and economic justifications. So like Kalpana was saying, one of the, my presentation is basically going to be based on the recent report that we've done on setting the direction of innovation. To give you a brief insight to these kind of reports, we at WIPO, especially in the Chief Economist's office, we feel that we have a role to play to bring economics insights and specific evidence to inform policy making. And we're not talking about delegates or policymakers in high income countries. We're talking about those from less developed economies where likely they don't have enough capacity to actually look into these specific issues and to give them a specific overview on how innovation is taking place, what is happening, and what are the potential challenges that they could be facing. So when we talk about intellectual property, for us, we look at IP rights as a tool to measure innovation. It is an imperfect measure for sure. And in fact, we say it is actually a measure of invention. So potential innovation that could, if it's commercialized, actually benefit society. So how do we make sure that the type of innovations that come out are actually beneficial? What are the specific policies? Who are the ones actually behind these innovative activities? And how can we continue to support them in order to come up with specific technological solutions that may be facing the society at large? And we're also talking about this not just from the perspective of, in high income countries, where many times one of the main arguments against intellectual property and those who actually enforce intellectual properties is that it's mainly owned by entrepreneurs and inventors in high income countries. What we're talking about is how would inventors in less developed economies be able to learn from those specific inventions and then hopefully adopt or adapt those technologies for what they need at home, given the capabilities and so on and so forth. So this is just a brief overview of my presentation today. So if you do have specific questions, please do not hesitate to ask me. I'm completely fine to explain specific things if I do lose you. So there are three parts of the presentation. Is to talk about what do we consider is an innovation ecosystem and who are the innovation stakeholders in digital technologies. We talk a lot about digital technologies, and this is one of the parts that we illustrate given some of the data insights that we have. And then I'm going to go into very quickly into why this is important. And three key messages. So in case you lose me along the way, these are the three things that I think might be important for you to take away. One is the fact that identifying the key stakeholders in innovation ecosystem is important. And I hope to be able to convince you of that part. Secondly, in digital technologies, the main stakeholders are in mostly high income economies. Then the third part is how policies initiatives play. They actually play out, they have a big role in the direction of innovation of digital technologies will depend on these stakeholders. And also it will have an impact on the innovation and innovative capacities that will take place in less developed economies. So a lot of discussion when we talk about competition issues, industrial property rights issues, or even issues about sustainability has an impact beyond your borders, beyond the Europe market, beyond the American markets. Right. So the innovation ecosystem. So what do we mean by when we talk about innovation ecosystem? We talk about generally, we divide them into three different key stakeholders, meaning the policymakers, the governments that actually fund the research institution and have sometimes their own research capabilities. academia, so universities, researchers that are in those universities coming up with new scientific progress and technological progress that can influence what we will be able to benefit from in the near future. And then you have the companies that are basically the ones that tend to not only innovate in some of these areas, but also commercialize, right? Because when we talk about inventions, we're really talking about the potential for these particular inventions to have an impact on the society if they're commercialized. And if you start looking at what type of inventions actually get commercialized, especially in the medicine sector or even the agriculture biotechnology sector, you start realizing that the attrition rate is pretty high. And so there are some elements to why you end up seeing, like, for example, in agriculture biotechnology, that you have very few, like you can count them on one hand, that's gatekeepers on commercialization of these genetically engineered products or crops. So these three stakeholders, usually what happens is there are other factors that also determine the direction of innovation. And that has to do either by policies that governments have, that can also be determined by exogenous factors such as the pandemic. I like to give the case of the QR code, where at some point it was huge and then it went out of favor where we didn't really use it. And now because of the pandemic, it's back with a force. And in fact, we found a way of repurposing an invention that now benefits everybody and arguably has an impact on sustainability in the sense of pharmaceutical companies no longer have to print out the many instructions on how to use their medicine in different languages. You just have to scan the QR code and you can choose the language. So there are many things that actually factor in when we talk about who sets the direction of innovation. And one of the things that we had done, let me just go through this very quickly because these are the key trends that we've seen using patent data, right? We see that innovation in digital technologies is booming. We see that it's confined to private sectors, again, in high-income economies. And we see there's an increasing government attention to the field. And rightly so. We're not saying that this is something that shouldn't be done. There's some challenges that need to be addressed at the government level that cannot be addressed by private sector because they have their own objectives they're maximizing towards. Patent data. So when we say that digital technologies are booming, what kind of technologies are we talking about? So we're talking about, we generally classify them according to artificial intelligence, big data, cloud computing, autonomous systems or robotics, and the Internet of Things. You can arguably add more things in there. You could, but we just decided to look at these ones. And you can see that the share of patent filings has increased over the years, right? And if you look in terms of patent filings by the different digital categories, you see there's a huge increase in terms of autonomous system, and also artificial intelligence. Now, these sort of potential innovations, they're interesting and they give an insight into what is happening in terms of innovative activities worldwide. Okay. And if we look at how they've grown in comparison to patent applications, in general, you always see a trend of increasing patent filings over the years. In general, this is the case. But what you realize, and what we've realized looking at patent data, is that digital technologies have grown 172% faster than the average patent filing growth over the past 5 years. This is really fast. So what we're seeing is this boom of inventions by specific private sector and private sector companies looking at the different categories that we have. So we see this very bigly in artificial intelligence, in big data, robotics, autonomous system, cloud computing. Now on Internet of Things over the last 5 years, it's actually decreased, which is also quite interesting. And we haven't actually looked into why this is the case. And then we looked at who are the top participants of or who are participating in this innovative activity. And we see the US, Japan, Korea. I'm sure most of you are not surprised, but also China in the recent years. And what's interesting here, you don't see it, maybe I can move it. These are actually patent applications by type, applicant sorry, no, this is not applicant type. This is actually by first filings, single filings. So the blue line is actually the total number of patent applications filed in those countries, right? So these means that if it's granted, then those particular rights holder will be able to enforce it in that country. The red line, if I'm not mistaken, is there a way to move this so I can see the line? Sorry about that. Oh, no. No. Is there a way to move it? Just this part. Yeah, sorry about that. What we start seeing is that most of the patent filings on digital technologies in China are mainly filed in China, which is very interesting because the market is big enough that they don't have to go overseas. Whereas when you see, for example, the US, yes, thank you. So we call them singletons. Whereas in the US, you do see there is a huge overseas patent filing, which means that not only do they file in the US, they also file overseas for protection because basically what they, thank you very much. Basically what they are anticipating is that there is a commercialization potential overseas, but not in China. So that's a very interesting innovation ecosystem perspective or insight. And it also gives you an insight in the sense of what's happening in China, what type of innovation is happening in China, and is it going to stay in China itself? As I mentioned before, most of the inventions are by private companies. So we have here a breakdown between academia, individuals, and companies. And based on the data that we've seen, a lot of it, right, at least at this moment, is coming from private companies. When you think about the origin of digital technologies, is mainly by most of the research done by the public sector, but somehow it is being commercialized and taken up by private companies. With some slight differences, of course, jurisdiction. So you do see here, for example, in China, the public sector is quite a big participant in terms of patent filings. In China as well. If you have an in-depth look at artificial intelligence related inventions, you have them by applicant type. And here again, you see companies are the leading applicants who file for AI patent filings, followed by academia and individuals. But when you start looking at them in terms of total filed by type, AI is the one technology where the academic and public sector are filing for patent protection more than other technological fields. That's a very interesting insight, because in the sense of what's happening behind in those universities, in those institutions, what exactly are they thinking in terms of commercialization? Now, here is an interesting part, and this is where the discussion about not only developing countries, but also participants outside of the main innovation ecosystem of digital technologies come in. So when we look at the share of international co-inventions, we see that for a while it was booming until about just a little bit before 2010, it starts decreasing, which is quite interesting because it's also the sense of when you see co-inventions, you always see the sense of inventors or in different firms collaborating with one another. And also it's no longer that open. It's starting to be a bit more closed in the sense of the private companies are saying no longer are we going to co-invent because maybe some of these elements are very useful for us. And so we don't want to share that discussion, that know-how. And who are these at the moment when we're talking about co-invention? Who are these inventors collaborating with, and where do they reside? This is a diagram. Basically what we've done is we've looked at patent applications, we looked at who the inventors are, and we looked at where do they reside. And you can see very clearly here that the US is a big applicant in the global world of innovation ecosystem. And you can see who they're collaborating with. And you start seeing that there are places like Singapore that all of a sudden shows up in terms of the innovation ecosystem. You see Not surprisingly, India, China, Spain, Switzerland, and so on and so forth. Now, these are just represent the 10%, the top 10% of international co-inventions. But what this underlining this data, what it says is that if countries like in developing countries, if they have the capability, if they have the appropriate level of inventiveness, when they collaborate with inventors in the US, they could also participate in the innovation ecosystem of moving the needle forward on digital technologies. I think this is one of the last slides. This is another interesting one. So bear with me. This is basically a link between the applicants and where they're getting their knowledge of digital technology from. So meaning the inventors. So if you see here, you have applicants like the US sourcing in insights from Indian inventors. And you do also see the US being the source of knowledge for other firms that are from Germany, Canada, Japan, and so on and so forth. So it's a very interesting dynamic in the sense of you see where the applicants are, you see where they are trying to source in knowledge, you see that they're trying to actually innovate in this particular digital technology field. Of course, you have factors that affect innovation. We talk about local capabilities, for example, Horizon Europe, Germany's Industry 4.0, Made in China 2025. And what's interesting and what we note for many policymakers is that a lot of decisions that are being taken in Europe and also in the US affect the kind of innovation that developing economies see. And in that sense, the question then becomes, if inventors in developing countries want to participate and learn and take advantage of the digital technologies, can they? What do they have to do? And these are some of the things that we need to think about when we're talking about innovation ecosystem, because we want innovation to eventually affect societal change, improve standard of living when it is commercialized. So how does this affect competition? So when you, as researchers who talk to competition authorities or influence the direction of all these specific policy recommendations, then you start thinking about, I'd like you to start thinking about what's the scope of the market. Maybe the scope of the market is not just Europe. Maybe it's not just the US. What about consumers that are outside of these specific jurisdiction? You know, it's just a way of thinking about it. You don't have to take it seriously, but just think about it, because it does affect, because this direction of innovation is not just going to affect consumers at home, it's also going to affect consumers overseas. And then the implications also include how to tailor appropriate resources to mitigate certain negative impact on society. Again, whatever effects in Europe might have a negative implication for developing countries, people in developing countries. So it's something to think about. And I think that's about it. I'll have enough time. Thank you.
Thank you for that lovely presentation. Now we have Konrad Kollnig, who's an assistant professor at the Law and Tech Lab, and he recently did his PhD at the Department of Computer Science at the University of Oxford. And I also had the pleasure to do a paper with him. So, Konrad, the floor is yours. You want to discuss the paper?
Stand up, maybe.
Let's see if I can. You want to sit there? You don't want to sit.
That's it here.
Yeah, please.
Thanks so much. That was very interesting. I've got about 4 points. I'm not quite sure if they are particularly related. They might, I think they're all sort of a little bit related to the role of the state, but maybe not. I think the first point of the sort of the first message of identifying stakeholders and really pointing that out, emphasizing that very much chimed with me. sort of in the computer science world, I think that gets often sort of that often doesn't get so much enough attention anyway to really understand your stakeholders, your problem, and you set out develop something that doesn't work. And that actually is the number one reason why digital innovation fails. Yeah, super interesting point. I think there might also be an interesting angle of thinking, what does identifying stakeholders mean for the question of regulation. There's all sorts of regulation coming out now from the European Union, other jurisdictions. And I'm trying to put myself into the shoes of, say, the average software developer, small, medium enterprise. How are they supposed to keep up with all of these new laws that are coming up? There seem to be still, they seem to be struggling already a lot with, say, how do we ensure GDPR compliance? There's lots of anxiety around non-compliance, and that obviously can have negative effects on innovation. So, maybe the point around education is, very much related to, after having identified those stakeholders, thinking about how, what's the right way to engage with them to contribute to innovation. I've got a bit of a methodological sort of observation. I guess it's very difficult. I understand it's very difficult to measure innovation, to define information, to also define what good innovation is. Right? Guess for decades we've been innovating in carbohydrates, and now that's not good innovation anymore because of climate change. So regulation is kicking in. But obviously in your talk, you took the perspective of patents as a measure of innovation. And I understand that that's a fair approach. I guess there's also an element of keeping in mind that more patents in certain areas might also go the other way, that they inhibit innovation, that they are used to sort of block market access to competitors. And highly recommend the book Toxic Competition, in that it's not quite about just patents, but about how you could square those challenges. And then lastly, you mentioned the point that most inventions, based upon the data, that most inventions came from companies, and I see how that emerges from the data. I think what should probably also be acknowledged is, with some of the high risk innovation, that a lot of innovation actually comes through public investment. And Mariana Mazzucato's book, The Entrepreneurial State, is very insightful in that concept, where she dissects the iPhone, says, well, GPS inside the iPhone was a military invention in the US. Internet came from the military in the US. Touchscreen came from the military, and it was a DARPA project in the US, and so on and so forth. So, for these high-risk projects to really kick off innovation, public investment is probably very, very, very important. And then it's very interesting that, looking at the patent data, still most of that seems to get captured by private entities. So maybe there's a problem. I've got two questions. That was just some observations. I've got two questions. You've obviously, given your role, been looking at patents. Now, as far as I'm concerned, I cannot even patent software in Europe. So, what role do patents then play for AI and all of these digital innovations? And then again, putting myself in the shoe of, say, I'm a computer scientist, putting myself into the shoe of small, medium enterprise, software development. How am I going to keep up with all of these there's tens, and you said there are tens of thousands of patent filings in these industries. How am I going to keep up? Yeah, that's it.
Thank you, Konrad. These are all very relevant questions, and questions that we actually would love to look into. So on the question of looking at patents, we are completely aware that in many cases, especially when it comes to software, we're probably underestimating the type of what innovative and creative activities are taking place for that. So we know for sure, and that's why we always say that patents is a noisy measure. On the discussion about access to IP systems, and this is also another discussion and research work that we are undertaking, but it does take some time, which is how can you give access, you can make sure that entrepreneurs that are budget constrained be able to use patents, right, to apply for patents. And if you look at how much it costs to file for patents, not just patents at home, but international patents, it's ridiculously expensive. And for somebody who's residing in a non-high income economy, it starts becoming prohibitive. So how do you facilitate that access to the IP system so that then when they do want to commercialize, and if they can, that their ideas are protected in some sense, right? And it's not an easy discussion. We did at one point look at what happens to if you reduce patent fees, right? And it goes that, yes, if you reduce patent fees, you'll have more people using it. But do you want to reduce patent fees? As an IP institution, your role would be to ensure that the type of patents that come out are quality patents. So how do you ensure high quality patents? You hire more patent examiners. How do you hire more patent examiners? You need more revenue for that, right? You need more money for it. And in some cases, like the USPTO, the money they actually make money from that. Now, the question is, then do you want to have a patent institution or an IP institution that just rubber stamps patent applications, in which case it's not a good idea, because then you go into the whole discussion of, are you allowing for patents that are not high quality to go into the market and potentially hinder any further innovation? So there are many elements that we would love to look into, but it's not so simple to look into. But just on the WIPO, we have a patent cooperation treaty system, which allows for one filing. And we do have fee reductions for inventions that come in from less high income countries or less developed economies. The problem is it's not enough, because in order to file for patents and to actually draft the patent itself, that's a specific art, in which case then you have to hire patent lawyers. So it starts becoming very, very expensive. And we do realize that this is perhaps not the best way of promoting innovation, of encouraging innovation. But at the same time, it's the only tool that the governments have to encourage innovation in a decentralized way. Right, so it's the patent, the IP rights holder that decides what they're going to invest, how much you're going to invest, and take it to. And if that invention becomes successful, then eventually profit from whatever patent rights they might have on it. And governments don't know much, right, in terms of the markets and so on and so forth. So in that sense, the decentralized aspect of IP rights makes it a very attractive policy. But yeah, the debate continues, and where do you start? Where do you stop? What's patentability? What's not patentability? These are all different. And for many companies, some of these issues start becoming very difficult, especially if they want to commercialize globally, because different IP offices have different patentability criteria and what is patentable and not. So we can go many ways. I'll stop there if that's okay.
Good. Any questions from the audience? Yes, lots of them.
Oh, wow.
So there's some running around to do. Let's start from Ian.
Thank you.
Well, I don't think it's on.
Is that on now? Yeah. Thank you very much. Intellectual property law is different to intellectual property rights. And I think, picking up on your idea of good innovation, there needs to be some qualification, I think, in the language that is used. Intellectual property law is carefully constructed over hundreds of years to strike that balance between rights and uses. And worldwide, what we've seen is essentially the ease with which data is captured over patents to show innovation, because there is no mechanism by which we can capture data around the barriers that IP rights are creating. There's no easy way because we don't have a government department that can capture that data. But we have government departments that make a lot of money from registering design rights, patent rights, trademarks, for example. So in Australia, one of our biggest challenges was that our productivity commission, full of economists, said, where is your data that there is a problem here? How do we demonstrate to WIPO that there is a problem with the balance in IP rights and IP users and in intellectual property law? Because it's not the World Innovation Property Office, it's the World Intellectual Property Office. And I really honestly ask that question because there are developing nations struggling with access to food because of the digitalization that's happened on farms. And that is not patented, that is copyright. And there are people who are not being able to access repairs to their wheelchair because of copyright. How does that story get told to policymakers? Because we cannot gather data around those stories.
Or do you want to take
We can probably
questions?
take 2 or 3 questions together. Next one.
Yeah, sorry, I'm going to be quick. The graph on patent filings showing China, Japan, Korea, and the US, and there was not Europe.
Oh,
And
no,
couldn't-
there is. It's just, I just took a
Okay,
snapshot.
all right, all right,
It's just
okay.
that you look at the top. If I showed everybody
Okay,
everything. it's
no,
not-
no, 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 no. But the thing is that obviously Europe is not on the top then. And then I was just wondering whether you even consider Europe as a block for your data, or whether you consider individual member states, because yeah,
Mhm.
so just that.
So we consider, so Germany is definitely there. It's just, I didn't point it. It's Germany's there, France is there, and then many European origin applicants are there. It's just that it wasn't shown there. So if you want, we have the data, no problem. And they all consistently show up. No, yeah, Europe consistently shows.
Hi, thank you for your work as economist. I really appreciate, I'm economist too, so I can relate it. Coming back to this goods innovation, I'd like to know if you have measured this digital technology increase. Have you taken account the tech-enabled sustainability solutions as a digital technology improvement?
I think one of our colleagues
Thank
is
you.
doing that, yeah. But it's not us. But yes, there is some. The nice thing about patent data is you're relying on millions of records. So you can exploit that information. The downside is that you're exploiting information of inventions by usually rich multinationals or companies that are able to patent in different jurisdictions. So yeah, there is always an underestimation, but you can exploit the data, and which makes for economists very, very nice because you have detailed data on the location, who the inventors are, and so on and so forth.
Yes, I've got the mic, Kalpana, thank you. Some comments and also some questions. So it's interesting in this context that we are talking about large firms and SMEs. And this is interesting because if you look now in the context of Europe's effort to make the patent system more accessible through the European patents with unitary effect. The definition of SMEs has changed. So it's small and micro-sized enterprises, no longer medium-sized enterprises. So your question before, how should I know as an SME? Well, perhaps you only benefit if you are micro-sized and small, no longer medium-sized. You're supposed to do all the work yourself. Just to give you an idea, just to start litigation under this new system, the Unified Patent Court bring 20K simply to start legal proceedings, because the court, like a patent office, is supposed to finance itself. So the member states are not even paying for providing access to justice. No, the users of the system have to pay for access to justice. I think this is the biggest problem underlying the there are many other problems with the UPC, but this is one of the biggest ones. So it is a game for big players, patents. And it also clearly doesn't equate innovation in the digital realm, because what we cannot measure is the value of big data analytics, and the capacity to receive that data and to process it, because that is what drives a number of these patented inventions that were listed. And so that's also an interesting element here, because most of that data is sourced from all around the world, but processed once more in the richest countries. So that there is an effect there that really reinforces itself. And then there was also the comment that, oh, I cannot even patent software in the European sphere. Well, that is true on paper. Software is not patentable as such, but computer implemented inventions are. And many of the ones listed here in relation to AI uses are computer implemented inventions. So this may not help you as a programmer, because the functionality of or sort of the expression of your computer program is perhaps protected under copyright. But unless you manage to get one of these computer implemented invention patents, functionality can also be freely copied. That's a bit of the idea. Curiously, the policy idea was always we shouldn't have these types of patents in relation to software, because the European landscape for software development relies on SMEs, and we shouldn't get these big parties involved. So that was always the policy consideration. So perhaps that now changes, because in essence, Europe doesn't have a major software company. They're all US based. So this may also explain some of the sort of backlog in terms of patent filings coming from Europe, even in the new AI sector. I have some questions as well, though, in relation to your data and what they tell us. Most notably, China. Can it be that the number of international filings has gone down significantly because China has stopped its subsidy programs for international filings? Or are there still some subsidy programs in place? Because that explained a bit of the large increase in Chinese patent filings. So now that you say, well, they only remain within China, yeah, I don't know. Perhaps a number of these companies, now that they no longer have access to these subsidy schemes for international filings, will simply file in China itself. And on the other hand, I would say, great, let them file in China. They disclose, and that means if they don't have patents elsewhere, the rest of the world benefits. So on average, though, what I hear is that the quality of the patents granted by SNIPA is not at the level comparable to that of the US and to Europe. So I don't know what this actually tells us about innovation if we also do not measure the quality of the patents, and the rate of applications also don't tell me much. I am more interested indeed in, is there a patent family? Are maintenance fees paid, and for how long? That tells me something more about innovation, because otherwise simply patent filings to me without the correlation don't tell me much. So in other words, have you looked at this? Because otherwise it would seem that the report tells me something, but I'm not quite sure what it is supposed to tell me, despite the nice title on the cover page.
Thank you. Let's see, how do I go about addressing any other questions before I say? Oh, yes.
Slide 20.
Yeah, sure.
Slight question on my part as well, which basically answers the question that, or my fellow academics has also asked. Basically, what I'm wondering was, you're indeed looking at the total number of patent filings, which kind of makes sense, and they give you very interesting, from my perspective at least, insight about what's going on in these technology markets, and they also reflect the general tendency that we all, well, find as well. However, we are looking, I think, at absolute numbers, like numbers of patent filings, and this sort of looks, in my eyes, the degree of inventiveness of each individual patent. And I think there are quite a lot of questions that remain in this respect. Namely, again, what is the quality of each individual patent? And I was wondering, from like a more methodological perspective, are there certain approaches that we could adhere to, well, try to identify how much a certain specific patent is truly or genuinely adding to the state of the art? What is the degree of inventiveness of a certain patent? That way, we're no longer looking at these absolute numbers, which was also the critiques voiced by you, but we're looking at one patent versus the other one. One thing that I read like a long time ago is that sometimes they use like 4 patent citations and so on, like how many times it is subsequently cited. But you're obviously the expert on WIPO, and I'm very intrigued to hear more about how would you go about this. Is there a certain way where you can also, in addition to the quantity of patent filings, can also take into account the quality of each respective patent?
Okay, so I have what, 5 minutes to respond to them?
Yeah.
Okay, so I'll try to do my best. If I don't manage to answer the questions, let's just have a side bilateral discussion. On the question of quality, how do you define a high quality patent? This is a very difficult and challenging thing to look at, and in fact to measure. I mean, you're comparing apples and oranges if you look at one patent application in digital technology versus one patent application on a specific medicine or vaccine, right? How do you measure that? It's not so simple. And then you're basically, for some of us, some economists, one way of we looking at quality is we ask, well, how does it fare up when you try to enforce it, right? Then you get into a discussion of how do you enforce it and who can enforce it? And there are many cases here where you see that when you talk about enforcement, it's all about litigation, who has enough money to actually go for the litigation. So then you start getting into these difficult discussion of what is a quality patent, and then let alone talking about different IP search offices and how their quality is measured, right? There's one controversial paper that said the EPO has the best, let's say in terms of search examination, they are the best. But if you speak to the USPTO, they say, well, we beg to differ, right? So can you do that? We economists have tried to look at citations, right? The number of citations. So we say a patent application is of high value because it's being cited many times. And then we had a technical patent examiner who came to us and said, no, you're looking at it wrong. It just means that if you have many citations, it's probably because the technology or the solution hasn't been found. So the problem is still there. You just haven't found a solution. And this patent examiner actually said to us, you know, sometimes you have one patent application that solves the technical problem and it won't have any more citation, but it's high quality and it's a good value. And it ended up being an innovation that solved that problem. Then your patent citation argument goes out the window. It's not very simple to answer all these questions. And there are many discussions on, okay, patent metrics, what are you looking at? How do we deal with China? Still ongoing. We haven't resolved it. So we say, okay, let's look at patent grants. Some IP institutions, I won't name names, take 7 years on average to grant a patent application. So, I mean, what are we talking about here? I mean, is it tech life cycle over? Then they say, okay, what about renewability? So if you maintain a specific patent over the course of the 20 years, therefore it's high quality. Again, the question is, well, is it though? What happens if there's a new invention that comes along that completely radically displaces the old invention? In which case, why would I, as the inventor, continue to pay maintenance fee on a patent that nobody really uses? Again, so maintenance fee is not a good way of going forward. You can go on and on and on. It's the kind of research work that we engage in and the economists, my peers in the different IP offices engage in. There's no solution. And Professor Wiseman, on your question about how are the stories about difficulty to access innovation, how is it collected at WIPO? Basically, there's no systematic way of collecting this. And if at the national level, it's difficult, imagine at the international level. So we do have, for example, NGOs that come and give us stories, but unless it's backed from the national offices or different governments that say, well, here's the data that we've collected, how can we move forward on this? It's difficult for WIPO to move because at the end of the day, we are a multilateral organization and we are basically trying to administer specific agreements that have been negotiated by over 100 member states. And so sometimes we say, well, depends, it has to go back at the national level. The easiest way forward, Can
I just ask one quick question?
Yeah.
A WIPO treaty, the Marrakesh Treaty.
Yes.
Negotiated with everyone.
Yes.
Implemented is being contracted out of by libraries all over the world. That's a really simple example. Contracted out of a very high-level, sophisticated treaty that was negotiated. It's one of your treaties, but it's been contracted out of.
Yeah, I'm not familiar with the copyrights. We have, I can put you in touch with my one economist colleague who's working on creative economy. It's copyrights is a different beast.
Okay, let's keep the beast under control. Also, I can see that we are not just hungry for food because it's almost dinner time, but we are very, very hungry for intellect and knowledge. But now I have to take you to the last paper for the day, which kind of also brings out a lot of things together and develops the theme for tomorrow, because we are going to go deeper into Digital Markets Act, and you also touch upon DMA in your paper. So we have with us the last paper for the evening, Christof Koolen, by Christof, who is doing his PhD at KU Leuven at the Institute for Consumer Competition and Market, and you're working on the Internet of Things, and you're going to present about interoperability in the IoT ecosystem. So please don't forget, we are all hungry.
Yeah, I fully realize this. Perhaps from this noise, please.
Sure.
Yeah, that's the one. And this up over. Yes, thanks. Voila. Wonderful. First of all, thank you all for witnessing my presentation, and good evening, and thank you for being here. My name is Christof. I indeed work as a PhD researcher at the Institute for Consumer Competition and Market at KU Leuven in Belgium. And during the next 15 minutes, I will take you through some of my work that's taken up in my PhD, which deals with interoperability in the Internet of Things. A quick question for the audience to try to get everyone a bit awake. Who among the current audience members is currently wearing a smartwatch? Do a quick show of hands. 1, 2, 3, 4, 5, 6 in the back, 7, 8. I counted, there were 31 people in the back, so that's like 1/3 of all audience members are currently wearing a smartwatch. Good to keep these in mind. Okay, smart devices and the Internet of Things. What are we actually dealing about? And what is this topic? What will the topic of my presentation will be? If we talk about the Internet of Things, we basically take an everyday device, take a TV, a watch, refrigerator, and so on. We equip that device with a broad scale of broad variety of different sensors, and thus enable the device to capture data from its surroundings. Then we implement some connectivity modules, which subsequently allow the device to connect to the internet and also to exchange information through this connection. Thus, by adding these sensors and connectivity capabilities to an everyday random device, it all of a sudden becomes context aware. It is able to act autonomously. Think, for instance, about a smart thermostat. It realizes, oh, wait a minute, there's no one present at home. I will automatically adjust the temperature to save you money. And this is what is happening in practice. Today, smart technology and the Internet of Things is a growing topic of conversation. Why? For the simple reason that you as an end user, you can derive certain very nice advantages from these devices. Think about convenience. Think about increased insights about your everyday life. This is, for instance, why I'm personally wearing my smartwatch. Think about saving money. Think about saving time. And the end point being that these devices are slowly but surely getting quite popular, and they're making their way into the consumer sphere, what I would like to say. Okay. This all sounds very nice and well. If you look at industry reports and consumer sector inquiries, you will find that on average in 2023, a Western European household has about 9 connected devices in the household. Leaving the numbers aside, the main takeaway of this is that you as an individual, if you decide to buy a smart device, this is not just a one-off purchase, but it is quite likely that you will buy over time a number of devices. And this comes with an implied expectation, namely that one device that you own also works together with the next device that you might own. And this is essentially what interoperability is. And if we take a look at the slide, we have a whole chain there. Let's say we have a smart lighting system. Ideally, you would like to be able to say, hey, Google, turn on the lights. And if interoperability works, then that voice command will be relayed through the smart speaker towards your lighting system, and the lights will indeed turn on. And that's essentially what interoperability is, the ability of 2 or more devices to establish a connection among them and to exchange information along this connection. It's useful to keep in mind that if we're dealing with smart technology, the majority of the value is derived by this ability to interconnect. And that's something to keep in mind for the remainder of this presentation. Okay, sounds good thus far, I suppose. Why does it matter for consumers? Why does interoperability matter for end users? If devices interoperate, this means that a consumer is able to mix and match smart devices of different brands. He or she can choose those smart devices that best align with their personal interests, and he or she can choose devices that are priced at a competitive price point. And this ties into an opposite concern. Conversely, non-interoperability means that consumers often don't have meaningful choice among the range of smart devices that are available on the market. Why is that the case, you might ask? Well, because a phenomenon which is called path dependency occurs. As soon as you buy your first smart device, you are locked into a sort of silo. You're locked into an Internet of Things ecosystem. And the reality is that devices from competing brands do not work together. Kind of makes sense to understand. The fact, however, is that you, once you've bought your first device, are locked into this ecosystem. At the same time, a competing vendor looking to market smart devices towards you will be unable to do so because you're already stuck within one system. There are significant switching costs that you experience, and you won't be able to, well, buy a smart device from a competing brand, and you are stuck with your single and only ecosystem. Thus, interoperability, if we consider it as a whole, is a matter of minimizing consumer welfare losses by being able to choose among a range of competitively priced smart products. Okay, root causes then of non-interoperability. I think two of them are the more important ones, and two other ones are slightly less one. First one being that there are very strong incentives to create closed off IoT ecosystems. Why? Because a firm can establish him or herself at several points in the technology chain. I am not only going to create a device, I'm also going to write an operating system, I'm going to create an application store, and I'm going to write some applications. Okay, great. This means that you can derive value at different points within this technology chain. And you establish yourself quite significantly, your market presence is quite significant. Second one being first mover advantages. I'm willing to say that Internet of Things and smart device markets are relatively emerging, relatively novel markets, with the effect being that these markets are quite susceptible to tipping effects. And we've seen this in the past already with a number of devices. Point being that there's a strong incentives to be first to market with your specific smart device and to, as quickly as possible, establish a large market share or acquire a large market share. Why? Because this is relevant to generate network effects, both in terms of number of users, but also in terms of collecting information and data. Technological fragmentation, this is the more technological side, obviously, different ways of arriving at the same solution, different use cases of smart devices. So this also ties into these interoperability concerns. Then lastly, proliferation of standards. In some market segments, there are a plethora of standardization efforts with no following whatsoever, basically. In other market segments, there are no standardization efforts whatsoever. And these all together tie into interoperability concerns. Okay, tackling these interoperability concerns requires taking a look at the theory of innovation. Let's go back to the basics, I would say. And let's start with the presumption or with the fact that interoperability limitations are not often of technical nature, but more caused by the existence of intellectual property right. I have certain intellectual property that is very much needed to facilitate interoperability between different devices. Okay, and then we'll have to look at the interplay between IP law on the one hand and competition law on the other hand. IP law, which exists to, well, contribute to consumer welfare by, well, enhancing innovativeness. If you're an innovative firm and you create an invention, you are entitled to the rewards of your inventiveness. We will confer a bundle of exclusive economic rights upon you, and you should use that bundle of rights to recoup your initial investment costs, right? Kind of makes sense. However, if you decide to use that bundle of exclusive economic rights to behave in an anti-competitive way, to try and foreclose the market, then this is where competition law will intervene. I've visualized this by a balancing scale because many authors in literature refer to this as a carrot and stick approach. Intellectual property law serves as an incentive to be innovative and gives you the necessary rewards for doing so, whereas competition law acts as a stick. If you're abusing these bundles of economic rights, we will come after you with competition law remedies. Ideally, at the end of the day, it's about trying to find the right balance between inventiveness and effective competition. Okay, during a couple of presentations ago, the question arose, okay, when do we need competition law intervention? Okay, then the answer is always, okay, we need market failure. 3 sources of market failure were identified throughout my research. First one being the existence of market power. Again, many of the instruments of interoperability, many of the tools to facilitate interoperability are concentrated in the hands of select few firms, with the effect being that those individual firms are able to an appreciable extent, behave independent of competition. They can unilaterally decide on the level of interoperability experience in the entire ecosystem. Add to this the existence of barriers to switching for consumers. Add to this that sometimes consumers are simply buying the wrong smart device that doesn't work within their ecosystem because they are unaware of these restrictions. Okay, let's take a step back. What are we actually dealing with? The main concern here within this presentation is the existence of so-called de facto standards. I am a firm. I have developed proprietary technology for interoperability. I was the first to market with my technology. I was able to tip the market in my advantage, and now everyone else is looking to trying to interoperate with my system. At that point, I am likely to qualify as a gatekeeper in the sense of the DMA, in the sense that I can determine which app, for instance, gets put on the Apple App Store or on the Google Play Store. That is the sort of the situation that we're dealing with. Okay, and then you basically apply the reasoning under Article 102 TFU for convenience sake. 3 steps. First, what are the relevant market segments? Second step, is there market power? And third step, is there abuse? In the research, again, 6 primary market segments were identified. You can see them on the slides. It is about hardware, software, connectivity, smart devices themselves, platforms, and applications lastly. Okay, moving on, market power. These were the findings of my research. A lot of information contained on one single slide. What is important to realize is that at the software market segment and at the platform market segments, those parts of the market are relatively consolidated. And you will realize that if you, well, with a bit of fascination, well, a bit of fantasy, you realize that it's sort of shaped like a bottleneck. In these middle market segments, there are relatively few negotiation partners, with the effect being that you as a firm might expose yourself to being foreclosed if you have to negotiate with these specific market layers. Okay, what kind of abuses are we then dealing with? In this case, the first one being is technical tying, and the second one being refusal to deal, refusal to license. And I think this sort of should make sense. Okay, combining everything together. Abusive refusals to interoperate, this is essentially what we are concerned with under competition law then. And this hinges on 3 steps. First, an ability to impose a standard on the market, the de facto standard. Then you refuse to interoperate with some market actors. And third step, this refusal to interoperate causes harm to the competitive process. Okay, and this brings us to the next leading question. Okay, sounds all great, but are interoperability obligations actually necessary? And when would they be necessary? Okay, let's dive into this. First situation, let's look at a vertical ecosystem. We have a platform, we have a particular smart device, and at the end, we have an application. Okay? There are essentially 2 ways to achieve interoperability in a vertical situation. First one being an ex-post competition law intervention. You have all the information in hand to facilitate interoperability, but you are refusing certain entity, third-party entity, to interoperate or to enter within your ecosystem. Can this be remedied by a duty to interoperate ex post? Yes. How would we go about that? By applying the refusal to deal test under Article 102 TFU. Are there examples of this? Yes, plenty. Recent one being a case by the Italian Competition Authority where Google refused to allow a certain application to arrive on the Android ecosystem. Okay, moving on. Can we prevent interoperability limitations from arising in the first place? And here the answer is, I think, also yes, but this requires a regulatory intervention, of course. And we have a specific example of this in the Digital Markets Act, where if you qualify as a gatekeeper, you must facilitate interoperability between the operating system that you own and third-party software looking to accede to your ecosystem. Okay, then a more philosophical question, is it actually desirable to introduce interoperability in a vertical setting? And I think this is the case if firms are vertically integrated. In that case, those situations might require further scrutiny. Why? Because those firms face very strong incentives to non-interoperate. They have a market presence at different layers of the market, and thus they can engage in leveraging conduct, they can engage in self-preferential conduct, and so on. Conversely, if you're dealing with a firm that is only active in one single market segment that is not vertically integrated, well, then that firm will have very strong incentives to try and attract third parties to its ecosystem and to generate value within that ecosystem. Okay, moving on. Last situation, horizontal interoperability. We're now looking at, let's say, 2 different brands of smart lights. Let's Philips Hue and, I don't know, Siemens something lights. Same question, can we achieve horizontal interoperability? From an ex-post perspective, I think the answer is no. Why? Because firms are direct competitors. They belong within the same market segment, and as a result, there's no suitable theory of harm to apply here. An example of this is the so-called iOS green bubble, blue bubble divide. Essentially, if you're texting between 2 iOS users, that will those messages will be sent across with a certain protocol. that gives additional functionality, the 3-dot I'm typing indicator, encoding technology, and so on. However, if you're texting between an iOS user and an Android user, these additional functionalities are not present, and the iOS user will receive that text message as a blue message. Okay, no ex post intervention, but can we prevent it ex ante? And here the answer is again, yes, might be possible. And a good example of this is the recent initiative to launch a common charger for mobile devices in the EU. Then we again move on, we're almost there, to the desirability of horizontal interoperability. Do we actually want to be able to horizontally interoperate between different brands? And the answer to this question is quite complex. I've tried to go about this through a two-stage test. First element being, do consumers have the ability to multi-home? If they can acquire the same software or the same device to achieve the same functionality, and there are no significant barriers to do so, then that will be the preferred way to go. More on that later. If the answer, however, is no, consumers are unlikely to multi-home. For instance, a consumer won't buy an iPhone and an Android phone at the same time, given the price cost associated with this. Then we arrive at the next question. Can market entrants viably enter and contest the market, or are there certain barriers to market entry? If the answer to both questions is no, then there are, well, it could be argued that horizontal interoperability might be necessary. Okay. Let's take, and to close out the presentation, let's take a look at these, the common charger then. This is what the whole charger landscape looked like a couple of years ago. We have to go back to 2008. There were 30 different charging solutions in the EU. European Commission said, nah, this doesn't work for us. This doesn't work for European consumers. We're going to simplify this. And we're doing it on a voluntary basis. And the effect being, from 30 charging solutions, we went back to 3 charging solutions. Great, you would say. And a couple of years ago, European Commission revisited these initiatives and realized, wait a minute, we are still dealing with a rather fragmented landscape. We're now going for mandatory harmonization. 3 charging solutions will become 1 single charging solution, the common charger of the EU. Effect being that for the EU, as of 2024, when it will be enacted or will enter into law, USB Type-C, so this one on the right of the slide, will be the mandatory common charger in the EU. Effect being that companies that opted to use a proprietary connector, for instance, Apple's Lightning connector, they will be forced to abandon their proprietary design in order to adopt the common standardized design. Question being, was it a good idea or not? And there are positives and negatives attached to this. Positive being, it lowers obviously e-waste, and this is one of the primary points that were advanced by the European Commission. It becomes possible to replace your phone while keeping your charger. It becomes possible to acquire charging without buying a phone. And perhaps in more social situations, you can easily borrow different chargers from friends and family and colleagues and so on. However, I also want to emphasize the negatives, and this is relevant because it's not always a push towards interoperability. It's always a nuanced answer. As soon as you set interoperability in stone, the effect is that the technology itself is frozen in time. It's stuck in time. It removes all possible incentives to innovate for the foreseeable time, and deviations are no longer acceptable. And this raises interesting questions. For instance, let's fast forward 5 years. Will we still be stuck with USB Type-C as the common charging solution? Or, absent these standardization initiatives, would we have superior technology without the common charger? There's an open question. I obviously don't have an answer for this, but in any case, it's food for thought. And this is one of the ideas that I would like to leave it off with. Conclusion, interoperability limitations prevent different goods and services from working together. Interoperability itself is a spectrum spanning from full interoperability to no interoperability at all, and it relates to horizontal situations between different devices in the same market segments, and also to vertical situations between platforms, devices, applications, and so on. The perspective of different marketplaces is relevant to take into account. If you're first to market, if you're often a relatively big player, there's incentives to not interoperate. Whereas if you're a relatively small player, you would happily to interoperate with these bigger players to partake in already created network effects and so on. Last question, do we need more interoperability? I think arguably yes. but we should be careful to think how we would go about it. A fully open IoT ecosystem is likely to, well, sort of undermine certain incentives to innovate in the future, and also runs the risk of attracting very low quality complementary products within the ecosystem. And those are the final ideas of my presentation. Thank you. The presentation is based on a paper which is published in the International Review of Intellectual Property and Competition Law. People interested in this topic, have a look at the paper. You will find more information than perhaps you would like on the topic. Thank you.
I can only add it's a beautiful paper, so very good. And now we have with us Mr. Thomas Graf, who's a partner with Clary Gottlieb, and he has worked in a lot of Google investigations, but he'll speak here as an academic and his position on the paper.
Thank you very much. Thank you for this very interesting presentation. You have very nicely brought out the implications of interoperability and the lack of interoperability and the legal issues that this raises. You also describe very nicely sort of the different types of manifestations of interoperability, vertical interoperability, horizontal interoperability, and how that might impact the legal analysis. But perhaps for me, at least, at the core of your presentation and your paper, there's a fundamental question around what is actually the concept of interoperability and how do we distinguish interoperability issues from other types of behavioral issues which potentially have a different kind of legal analysis. And you have advanced a number of sort of descriptions of what interoperability is, and sort of very classic descriptions, products interacting with each other, the ability of products to communicate. But of course, you can sort of interpret these in different ways. And if you're on the complainant side, there's going to be temptation to advance some broad concepts, because who could possibly be against interoperability? And it sounds always very good if you say that the dominant firm is obstructing interoperability. But I think you can see from the case law that not everything that involves products communicating with each other or interacting with each other is necessarily an interoperability issue. And I wanted to illustrate this with sort of three case studies, if you want, very briefly. And the first one is Microsoft, if you want, the grandfather of all interoperability cases in antitrust, the workgroup server case. And in that case, Microsoft was arguing, well, this is not about interoperability, this is about cloning. You're trying to clone my product and my core innovation. And we were on the complainant side, and we were trying to explain, like, no, this is not cloning. This is about communication. Actually, the analogy that we were trying to use is we only want the grammar for speaking with the Microsoft operating system. We are not going to steal the Shakespeare work, so we are not going to steal the content. We just want the ability to speak. And so it's the protocols, it's the interfaces. And that's what the court upheld, that yes, Microsoft was not being expropriated of its core IP. There was IP involved at the interoperability level as well, mainly trade secrets, but it was at the edge of the product. The product wasn't being sort of copied wholesale. And it's nice to contrast this with a case that there is not a lot of public information on that, but there was a case where we were involved as well. Now the defendant side, but for IBM is a mainframe case where the complainants were emulator companies. These emulator companies, these are software, this is software programs that imitate the mainframe so that the IBM mainframe operating system can run on sort of generic x86 servers, which are much more cheaper. Mainframes cost millions of dollars, and the generic servers are very cheap. And so these emulators wanted to copy the mainframe architecture and imitate the mainframe. And they were saying, this is interoperability. We enable the IBM operating system to interact with the Intel server, right? So there's interaction. We could say, like, this is interoperability. We said, no, this is not interoperability of the type in Microsoft. This is basically copying the core of what the mainframe is. You're copying the architecture. There are very important patents in this architecture, and you're you're copying the crown jewels, you're cloning, you're creating a clone of the mainframe. And that's exactly what the Commission said the dominant firm doesn't need to allow. And the Commission agreed with us in that case. And we were able, there is a very obscure footnote in the Microsoft decision about the request from Sun Microsystems originally, who wanted to actually port the Windows operating system into its own operating system, the whole API layer. And the Commission said, no, this goes too far. And so there's a cryptic footnote there that was blocked at an early stage, and that was not the issue in the Microsoft case. And that's what we relied on, but it's not easy to decipher from the decision. So that's one thing. So that's one sort of distinction. Communication, just a means of communication versus cloning of the core product. A second distinction that I would draw is between interoperability and access. And you mentioned the Italian Google Android Auto case. And I would describe this, and I should say that my firm is involved for Google on this case, and it's in litigation, so it's in the courts. But I would argue this is not an interoperability case. This is an access case. With Android Auto, it's not an operating system, it's confused with the Android Automotive, which is an operating system. Android Auto is a projection app, which allows you have apps on the mobile phone, and then you project them on the screen of the car. And Google didn't allow NL's app for finding electric charging stations to access this program. And Google's defense was that there needs to be a safety check, because if you put these apps on into this Android Auto, then you can create car crashes, and so you need to look you need to check for safety. It takes some time, but so there was a debate. There's always a dispute about that. But fundamentally, what NL wanted is an access into our app. This is not about the means of communication, it's not about the protocols, it's not about the interfaces. They are in principle there. It's just that Google says, like, I don't think you are safe enough, I'm not going to let you in, right? And so to me, that's not interoperability. And the court also, not the court, the authority didn't really do the Microsoft interoperability test with the refusal to supply analysis. And that that's not just us claiming that. The case is now in the second instance. The first instance court instance sided with the authority, but the second instance court has now issued a preliminary request to the ECJ, where it says, like, it recognizes, yes, the authority did not do the Microsoft test, but it asks the ECJ, does it have to do it in an interoperability case? So this is going to be very interesting, whether, is it an interoperability case, and does the Microsoft test still apply, or is there some kind of lower bar now in the new legal framework? So that's interoperability against access. And then sort of my last comparison is interoperability versus data disclosure. There's a recent case from the Bundeskartellamt, again against Google, here relating to Maps APIs and the Maps platform. And the Maps platform is a technology which allows you to incorporate Google Maps on websites and apps, and you can then show these maps to users. And the allegation is that Google doesn't allow third-party maps to call these APIs to get just the data about the locations, like the restaurants and the hairdressers and so on, and combine them with their maps. And so they say that's an interoperability issue, and they invoke a rule on 19a of the GWB, which deals with interoperability. They say this is an interoperability issue because the APIs, with interfaces, and the third-party map cannot interact with these APIs. And again, so we say this is not interoperability, because it's not about the interaction, it's not about the interfaces, it's not about the protocols. Again, they are there. What Google just says is, like, I'm not going to give my location data, my data about restaurants that I have collected, and my data about hairdressers, I'm not going to give that to a rival map provider. And so it is not interoperability. You're forcing me to basically wholesale license my content, right? That's what the real issue is, but that's an open debate. So we are in the middle of the debate around that. But so this is just to show there are sort of different questions there. Where do you draw the boundary? There are at the moment cases pending, which may sort of redraw this boundary, so shed additional clarifications, but they are important questions, because I do agree, like when you have a genuine interoperability issue, then I think that there are very legitimate questions. Should you enable this interoperability? Should there be, you know, a reasonable standard under which a dominant firm needs to enable interoperability? But it's also important to distinguish these cases from situations which may go beyond this sort of just pure interoperability issue.
One from my side a bit.
Very quickly,
Okay.
if you want.
Yeah, I think, yeah, at present, yeah, indeed, many cases still pending, and this kind of makes the assessment rather difficult. For the first point, I think it's relevant to keep in mind that under the classic Microsoft test, the 5-step test, two requirements that come to mind: the fact that there need to be 2 separate market segments, and also, more importantly for this specific case, the new product requirement. So the cloning argument would imply that, okay, you're trying to clone my product, okay, you will fail the refuse to deal test, okay, this means no interoperability for you. I think that kind of makes sense. Indeed, if there's a product that you're delivering yourself on the market, you shouldn't be forced to interoperate, and that kind of makes sense. The other points, the interoperability versus access, I think that's a very interesting one, and there are plenty of ongoing evolutions, both from a legislative point of view and also in terms of case law. And this makes me kind of reluctant to take like a fixed position in this respect. Sure, you could say access gets the job done, but interoperability would be like a more efficient way of going about it. It depends. I'm very hesitant to take a fixed position in this respect. Lastly, the data disclosure obligations. Yeah, indeed, because again, you're dealing with data sets that often contain proprietary elements, for instance, in terms of structure, and then we're in the area and realm of copyright law. And this rightly triggers question: should we be forced to share our data? Because that, for instance, would be enough to, well, get a market foothold, right? And I think many of these recent discussions will play out in the wake of the Data Act, where, for instance, a user can decide, okay, I have given you, Google, this information. I have manually added this information in Google Maps, and that's how many of these things work. And the user can decide, let's see what happens with my data. I can be the final user that decides what happens, and I want it to be shared with someone else. Yeah, that would be like a closing idea on that.
Very good. We have a question there.
Well, yes, of course, I don't want to stand between all of us and dinner, but
Go ahead. I'm very eager to look at
so anyhow, because also in relation to Thomas's comments, nice semantics, and of course the cases are ongoing, but really, can we confine ourselves to discussions on interoperability in relation to IoT when technology has already moved on? We have edge computing, we have cloud computing, and indeed, as you yourself have said, the information is provided often by users of these systems. So nice, Google, you have gathered some information on maps and God knows what, but the information that you have gathered is through your devices and through people using your system. So that brings me to the question whether we can continue to distinguish nicely semantically between interoperability and access. I'm not so sure that these boundaries will mean very much if we are speaking also about de facto standards brought about by data. And that brings me to the missing piece, which is data provided by users. So one thing I can really see coming is a demand for users to have a right of data portability in relation to their personalized data, all the data that they have imparted with whatever device manufacturer. If I want to switch from Google to Apple or vice versa. Can't imagine why I want to do that, but to suppose, then I want to have my profiles, my personal profiles, taken off the servers of Google and ported somewhere else. This is, I think, a demand that increasingly is put forward more vocally by user organizations and by consumers. And I also think that says something about the nature of the position of these undertakings, also vis-a-vis competitors, and that the boundaries between interoperability, data access, they must start to shift in this regard, also from a competition perspective. So perhaps not set in stone, your position, but do you also see the need for a shift?
A shift, I wouldn't necessarily. I wouldn't call it necessarily a shift. I will first circle back to the first element of your question. Should we limit this discussion to the Internet of Things? I think the answer is no. I don't think this will be a relevant discussion in, let's say, I don't know, 10, 15 years. Why? Because we already had this discussion with the rise of the Internet. Same discussion, same questions, basically. Now we are applying the reasoning here to a new technological phenomenon, Internet of Things, which is characterized by its own unique set of challenges. Fair, but I think the same problem will, in let's say 15 years' time, resurface again when we try to apply it to a different technological phenomenon. And this again, for me at least, illustrates that it's useful to keep the overarching perspective. What are we trying to achieve? And that is improving the situation of the end user. And for me, indeed, personally, I fully agree with you, whether we're dealing with cloud computing, whether we're dealing with Internet of Things or the Internet itself is perhaps slightly less relevant. Missing piece, data provided by the end users and that it should be ported. Absolutely agree. But the reality is that no one does this for a couple of reasons. I didn't want to go to the hassle. I'm quite fine with the status quo, even though I realize there are more superior applications and products available on the market. I don't want to go to the hassle. Second point being, yeah, you're locked on and it's fine. I mean, it does its job, but even though it's not like fully performant, it does its job. So I'm fine with that situation from the perspective of the user. And secondly, where am I going to port my data towards? We had the same discussion with Facebook and the Google Plus social media system. Well, okay, you can submit a data portability request to Facebook, but where are you going to port your data against? That's also something which is useful to keep in mind. I have thought about this, in fact, and what I think we might be evolving towards is a situation which we, at least in Belgium, have concerning energy contracts. If I'm subscribed to a certain energy provider and I'm not happy or no longer satisfied, I can just go to a competing provider and say, I want to switch to you as an energy provider. And that firm then will go about all the different steps and contact the initial firm and ask, okay, give me information of this profile because he or she wants to switch services to me. So you remove this step from the perspective of the end user and you put it with the firm that is trying to, well, attract more and more customers. Voila.
Can I just briefly add to the question, should the concept shift? That I don't know for sure, but if you look at the DMA at least, which is a very recent legislation, they do distinguish very clearly between different kinds of concepts. And you see that they have the interoperability obligation, 6.7, and it's only limited, as we discussed this morning, it's limited to operating systems and voice assistants, right? And they do have a data portability rule, which is considerably more broader because that, they see that, I think, as something indeed very desirable that the user, at least in principle, if they're not inert, that they have in principle this opportunity to take out their own data. While I think in the case of interoperability, I think there is also a recognition that sort of, even if you are within the sort of the core of interoperability issues, that it may not be very straightforward, an obligation to achieve interoperability, right? You may have to build new technology, you need to develop interfaces, you then also need to bring along the whole ecosystem, all these apps or services that then interact need to be accommodated. So there are a lot of issues. And so the Commission, I think, has very consciously picked operating systems and voice assistants for interoperability obligations, because those are products which are at the heart, their purpose is to interoperate, right? So the operating system, it consists of APIs, of interfaces that are meant to interoperate. Voice assistants, so the purpose is to connect you with a range of services. So that's really the core purpose. But it's less obvious in other instances.
I don't think that necessarily, that was more like a statement, right? Or because it still requires a response from my behalf.
I can bet that the discussion can go on.
Yeah.
But I really face a conflict between two sustainable development goals. One is access to food, which is SDG 2, and fourth, which is access to quality education and knowledge. And using the discretion as a chair, I tilt a little bit in favor towards the dinner now.
As you should.
Yeah. So with this, I really heartfully thank all of you for this wonderful contribution today. And I hope we can continue the discussion tomorrow with lots of parallel sessions and still one more keynote to go by Martin Schnuck in the plenary session. Thank you very much, and we join for the dinner. Thank you.
Yeah.
Thank you.